let's take a look at investigations and interviews in the workplace. Investigations of potential misconduct usually entail interviewing witnesses and interrogating employees accused or suspected of wrongdoing. Interrogations have enormous potential for gathering legal claims, especially false imprisonment and infliction of emotional distress. Statutes allow employers to take reasonable actions to protect their property against theft, but this does not include forcing employees to submit to interrogations or remain in the workplace against their will. Absent the need to stop the theft of employer property, employers should not attempt to detain employees suspected of wrongdoing or force them to submit to interrogations against their will. Instead, the cooperation of employees in investigations should be requested. If the employee refuses, employers have the option of disciplining or terminating the employee, or if a crime has been committed, involving the police. To minimize the chance of false imprisonment or infliction of emotional distress, make it clear to the employee that they're free to leave the interview. Do not threaten arrest, do not lock or physically obstruct the door, and keep them as brief as possible. Employees do not have the right to have attorneys present in these situations. However, union representation must be allowed for employee investigations that may reasonably result in discipline or discharge. This is referred to as an employee's Weingarten rights, named after the case in which the Supreme Court decided that such representation must be permitted to unionized employees because it's a form of concerted activity. The presence of a union representative must be requested by employees. It need not be offered. Routine conversations are not covered, nor are situations in which a decision to administer discipline has already been made. The union's representative role is circumcised. He or she is there as an observer and not to engage in bargaining over the prospective disciplinary action. The NLRB's current view is that non-union employees do not have any right to be accompanied by coworkers when being interviewed by management for possible discipline. The board reasoned that non-union workplaces should be treated differently because coworkers do not represent the interests of the entire workforce and more likely to compromise the confidentiality of investigations. The board viewed that employers should be allowed to conduct required investigations in a thorough, sensitive, and confidential manner.